Hello, and welcome back to A Little Privacy Please, my weekly series covering the latest developments in data privacy. I'm Julie Rubash, General Counsel and Chief Privacy Officer at SourcePoint by Didomi. This week, I'm focusing on two developments out of the United States. First, states are starting to get more specific about the types of data practices that require affirmative consent. Second, at the federal level, the FTC is signaling that protecting children online will be a major enforcement priority, even as it talks more openly about balancing consumer protection against unnecessary burdens on legitimate businesses. Let's start in Kentucky. Kentucky has passed a bill that would require consumer consent before a company collects smart TV automatic content recognition, or ACR data. The bill defines ACR data in a very detailed way. It covers data about a consumer's viewing history that is collected through technology embedded in or operated through a smart television or smart monitor with internet connectivity and an operating system. And importantly, it focuses on technology that can identify in real time the specific content being displayed by analyzing audio or video fingerprints. The definition sounds narrow, but it's actually quite broad. It includes content received through broadcast, cable, satellite, streaming services, or even external inputs, and it covers a broad array of techniques like digital fingerprinting, watermark detection, and similar comparison tools. Put more simply, this is technology that allows a smart TV to identify what you're watching, regardless of how that content is received and what method is used to identify it. At the same time, the bill does carve out some important exclusions. It does not cover data collected about a consumer's interactions with the controller's own content. It doesn't cover data generated while providing a feature or service the consumer requested, and it doesn't cover data collected to enforce terms of service. Unless the governor vetoes it, this amendment will take effect on July 1st, 2027. The practical significance here is that Kentucky is codifying a requirement that has already been enforced in another state, although through a less direct path. In late 2025, the Texas Attorney General filed a series of lawsuits against smart TV companies, alleging that they collected consumers' viewing information through ACR technology and sold it for advertising purposes without informed consent. Those cases were brought under the Texas Trade Practices Act, which meant Texas had to frame the conduct as false, misleading, or deceptive. In other words, the AG had to fit the alleged behavior into a more general consumer protection framework. One of those companies, Samsung, has already settled, and as part of that settlement, Samsung agreed to adopt consent-based ACR practices. But the Attorney General had to take the long way to get there. And that is what makes the Kentucky law notable. Kentucky is not just relying on a general deception theory. It is creating an express statutory rule that says if you want to collect smart TV viewing data, you need consent. That could make enforcement much more straightforward. Kentucky wouldn't have to stretch to fit the conduct into a general unfair or deceptive practices framework. Instead, it would be able to point to a specific statutory obligation. And under Kentucky's privacy law, the Attorney General can seek penalties of up to $7,500 per violation, which means potentially per affected consumer. That said, there's still an important procedural limitation. Before bringing an enforcement action, the Attorney General has to provide 30 days notice and an opportunity to cure. Even so, the takeaway here is that Kentucky is giving itself a cleaner path to regulate ACR practices directly. And for smart TV companies, this is another sign that consent for viewing data collection is quickly becoming the expected standard, not just a litigation risk theory. Okay, the second development comes from the FTC. The FTC has published its strategic plan for fiscal years 2026 through 2030, and one of the clearest messages in that document is that protecting children online is a key concern. Specifically, in its discussion of Strategic Goal 1, protecting Americans from unfair or deceptive acts or practices in the marketplace, the FTC now says that protecting children online is a key area where it is focusing its consumer protection tools and resources. The plan also identifies COPPA as the FTC's primary authority in this space. That language matters. It is a new addition to the strategic plan, and it is enforced by Chairman Ferguson's introductory message, where he describes protecting children online as one of the most important consumer protection issues of our time. Taken together, that strongly suggests that children's privacy and child safety issues will continue to be a major focus for the agency. Now, what makes this especially interesting is that the plan also includes another new addition that points in a slightly different direction. It restores the phrase "without unduly burdening legitimate business activities" to the FTC's mission statement. Chairman Ferguson says that reflects a commitment to ending over-regulation of American businesses that compete fairly and deal honestly with consumers. So, on the one hand, the FTC is elevating children's privacy as a priority. On the other hand, it is also potentially signaling that it wants to pursue that priority among other priorities in a way that does not overreach. And we may already be seeing what that balance looks like in practice. The FTC recently issued a policy statement saying it will not bring in COPPA enforcement actions against sites that collect, use, or disclose children's personal information solely for the purpose of determining a user's age without parental consent, as long as certain conditions are satisfied. That's a meaningful signal. It suggests the FTC is willing to make room for targeted, compliance-oriented uses of data, particularly where those uses are aimed at solving hard questions like age assurance, rather than treating every collection of children's data as inherently suspect. So my takeaway is this. Companies should absolutely expect continued FTC scrutiny in the children's privacy space. But that scrutiny may be paired with a more explicit effort to distinguish between harmful commercial exploitation and narrowly tailored compliance measures. In other words, this may not be a softer FTC on children's privacy, but it may be a more calibrated one. The common thread across both of these developments I've talked about today is that regulators are getting more precise. Kentucky is signaling out a specific category of viewing data and saying consent is required. And the FTC is making clear that children's privacy remains a top priority, while also signaling that it is thinking carefully about where enforcement should and should not fall. For companies, that means the margin for vague and generalized compliance strategies continues to shrink. Whether you're dealing with connected device data or children's data, regulators increasingly want to see that your practices are tailored to the specific risk. That's all for this week's episode of A Little Privacy Please. You can find more details on these stories in our weekly newsletter, also called A Little Privacy Please. I'm Julie Rubash. Thank you for joining me for this week's privacy episode. I'll see you next week. Until then, go enjoy a little privacy, please.